So here's a weird question for you. What happens if you guarantee a loan that legally shouldn't even exist? It sounds like a riddle, right? But it was actually at the heart of a real court case. And man, it teaches us a ton about promises, protection, and who's responsible when things go wrong. We're going to unravel this whole legal puzzle. Okay, let's make this real. Imagine you do a good deed for, say, a young relative. You co-sign a loan for them. Then, surprise, surprise, they don't pay it back. Now the bank's knocking on your door. Seems pretty simple, right? I mean, you sign the paper. But what if that original loan was legally garbage from the get-go? Are you still on the hook? That is the exact puzzle we're solving today. All right, here's how we're going to tackle this. First, we'll look at the special legal shield that protects minors. Then, we'll figure out what a guarantor's promise actually is. After that, we dive into the specific bank loan that blew up. We'll see the big legal showdown, and finally, we'll get to the court's pretty surprising decision. So, to get this whole case, we have to start with a really basic idea in contract law. You see, the law knows that for a deal to be fair, everyone involved has to have the capacity to, understand what they're actually signing. And for a long, long time, society's kind of agreed that young people just aren't there yet. So, the law gives them this special shield to protect them from bad deals. And the specific shield in our story is this old law, the Infants Relief Act of 1874. Now, here is the absolute key detail. This law didn't just say minors could get out of a contract. No. It said that most contracts for things like loans were absolutely void. Not just something you can cancel, but completely, totally void from the very beginning. Which brings us to this fancy Latin phrase, void ab initio. It just means void from the beginning, and this is a huge difference. This isn't like a contract that gets canceled later. It means that in the eyes of the law, the contract never ever existed. It was a legal nothing from the second it was signed. You got to remember that because it's going to be crucial. Okay, so piece one of the puzzle. A minor's loan can be totally void. Now let's bring in the second key player in this drama, the guarantor. What are they really promising to do when they sign that paper? A contract of guarantee is, at its core, a secondary promise. Think of it like this. You're promising to pay someone else's debt, but, and this is a big but, only if they don't pay it first. Your obligation only kicks in because there's a primary valid debt already there. The guarantee is the backup plan, right? It's not the main event. And here's where our two big ideas slam into each other. The law says a minor's loan is void. But it also says an adult's promise to guarantee that loan is a serious, binding promise. So, which one wins when they go head-to-head? Well, let's see how this all played out in the real world with the case of Coutts & Co. versus Brown-Leckie. This is where all that legal theory hits the cold, hard floor of a courtroom. So the facts here are pretty simple. You've got the bank, Coutts & Co. They give an overdraft, which is basically a loan, to a minor. To make themselves feel safe, they get a few adults, including our guy, Mr. Brown-Leckie, to sign on as guarantors. Well, you can probably guess what happened next. The minor couldn't pay it back, so the bank turns to the guarantors and says, all right, folks, time to pay up. And this is where things get really interesting, because the guarantors said, nope, not paying. And the argument they made created this absolutely fascinating legal problem for the court to solve. Okay, so the bank's argument was basically, look, a promise is a promise. These were adults, they knew what they were signing, they need to pay. Simple. But the guarantor's defense was so clever. They essentially said, wait a minute, how can we be on the hook for a debt that, according to the Infants Relief Act, is legally void? I mean, if the original loan never legally existed, what in the world are we guaranteeing? Nothing? So, who's right? Does the adult's promise to pay trump the non-existent debt? Or does the fact that the debt was void just make the whole guarantee fall apart? Let's see what the court decided. The court's logic came down to this really simple but powerful idea. Because that original loan was void ab initio, a legal nothing, the debt itself was like a ghost. And the court basically said you can't be legally tied to something that isn't even there. You cannot guarantee a ghost. So here is the bottom line. The court found that the entire existence of the guarantee was hanging by a thread, and that thread was the primary loan. Since the Infants Relief Act made that initial loan to the minor absolutely void, there was just no legal debt for the guarantee to attach itself to. The foundation was dust, so the whole building came crashing down. Yeah, this chart just says it all, doesn't it? The minor's legal liability, 0. The contract was void. And because that primary debt was 0, the secondary liability of the guarantors also became zero. The bank walked away with absolutely nothing. So what are the big takeaways here? Well, first, a guarantee is only as strong as the debt it's backing. If that main loan is legally void, poof, the guarantee is gone too. This whole thing protects guarantors from being liable for debts that don't legally exist. But here's the modern twist, because you know the banks learned their lesson. Today, instead of a guarantee, a lender would use something called a contract of indemnity. Now, an indemnity is totally different. It's not a secondary promise. It's a primary, direct promise to the bank to cover their losses no matter what happens with the first borrower. It's a much, much stronger promise. You know, this case is over 100 years old, but it brings up this timeless question. When a contract fails, who should really bear the loss? When a deal just falls apart because of a legal rule that's designed to protect somebody, who pays the price? The person who was protected? The person who tried to help them out? Or the business that took the risk in the first place? It's a really tough question, and it's one the law is honestly still grappling with today.